Welcome to this scholarship highlight brought to you by the Center for Firearms Law at the Duke University School of Law. This series is a chance for us to further the center's mission of deepening and broadening the scholarly conversation around firearms law and the Second Amendment, and a chance to talk with scholars who are turning out innovative and interesting and engaging work about firearms law and the Second Amendment. My name is Joseph Blocher. Along with Daryl Miller, I am the faculty co-director of the center. Jake Charles is the center's executive director. And today we are very lucky to be joined by my friend and co-author, Eric Ruben, assistant professor at the SMU Dedman School of Law. We're going to get a chance today to talk about his new article just published in the California Law Review called An Unstable Core, Self-Defense and the Second Amendment. Thanks for being here, Eric.
Thanks for having me.
I'm looking forward to the conversation. Let's start just with the basics. Just in a nutshell, what's the article about?
Sure. So the article, it's called An Unstable Core, Self-Defense and the Second Amendment. And in the article, I consider a question that I think has some big implications for the future of the regulation of weapons, which is, what does it mean for self-defense to be at the core of the Second Amendment? So the article and the thinking starts, as much of this does, with Heller, the Supreme Court's 2008 decision, when the court dispensed with the understanding that the Second Amendment is primarily concerned with a well-regulated militia. Instead, the court said that the core, the central component of the right, is individual self-defense. The Supreme Court, however, in the majority opinion, failed to articulate what implications that has for Second Amendment doctrine. It didn't say precisely what that holding, that the self-defense is at the core of the Second Amendment, means for deciding cases on the ground. That failure, I describe in the paper, has led to some conflicting analyses and conflicting outcomes. So what the paper does is it looks at Second Amendment doctrine through the lens of self-defense doctrine. It asks whether or not Heller is consistent with self-defense law, and it also asks whether or not the Second Amendment might have something to learn from self-defense doctrine, whether or not self-defense doctrine might be useful in deciding some disputes about the right to keep and bear arms.
So one of the things that I find so fascinating about this article, which is just implicit in what you just said there, is this relationship between self-defense and the right to keep and bear arms is just so, it can be so hard to pin down, right? Like sometimes people talk about them as if they're the same thing. And you'll hear people say, talk about a regulation on arms as if it's a regulation on self-defense, when obviously they're not exactly kind of one for one. And yet, despite the fact that people talk about them interchangeably, until your article, I had never seen anybody actually take the doctrine of self-defense to see if it might have lessons for the doctrine of the Second Amendment. So I wonder if you could just say a little bit about kind of how you came to write it. Like, how do you come to a piece? How do you come to write an article like that?
So I think that part of it has to do with my background as a former criminal defense attorney, and I teach criminal law. And when I read self-defense in Heller, and Heller is emphatic about the fact that self-defense is at the core of the right. I think it mentions the opinions in Heller mentions self-defense over 80 times. And when I see self-defense, I think of something very particular. And I think in particular about the way that the law implements and limits the right to self-defense, and particularly the criminal law is very concerned with this. Now, of course, self-defense law itself is not static, it's been evolving, but there's some components of it, like the principles rooted in necessity and in proportionality, that have been around since the time the Second Amendment was written. So one of the things that really brought me to this, after reading the opinions, and Justice Breyer said something in particular that I could come back to a little bit if you'd like. But one of the things that really brought me to this is when you and I were doing our empirical study of Second Amendment case law, I came across a lot of opinions that were just simply neglecting self-defense altogether, and others that were invoking self-defense in this limitless way that seems to have little in common with the way that self-defense doctrine actually works on the ground. So I wanted to explore those inconsistencies in the way that courts are treating self-defense. And I also wanted to see whether Second Amendment law might be implemented similarly to how self-defense law is implemented. And I want to see how that might play out, at least with respect to some disputes.
It's a really interesting, like your response there gives me a lot of thoughts. Like one is that, the fact that you come to this conversation with an expertise both in criminal law just as a subject matter and the Second Amendment as a sort of, constitutional matter is itself interesting, because the scholars who come to this discussion often are just coming from constitutional law, right? They're people who have backgrounds in, the interpretive debates, or they come from other areas of, of constitutional rights law or something like that. And it's really interesting to see how somebody who has multiple lenses, like in criminal law and constitutional law, might come and look at the debate a little bit differently, which prompts me to ask a little bit about kind of how to situate your piece in this broader and developing world of Second Amendment and firearms law. So I know a little bit about your priors here because you and I have co-authored a piece on the future of Second Amendment scholarship called you can lead a horse to water, I think it's called, in the Duke Law Journal online. And I think we agree, I hope we do since we wrote it, that the field is becoming increasingly interesting and diverse, and there's a lot of kind of conversations going on now such that a new scholar entering the field can either join an existing conversation or maybe start a new one, but there's enough people in the room now that you can kind of speak with. Now, your piece is interesting because it's novel on the one hand, like we just said, no one had written this before. But on the other hand, I assume you must see yourself as in conversation with some existing scholarly discussion. So I wonder if you could say a bit about, kind of to situate it, like who are you in conversation with? Like who do you hope reads this? What do you hope to change just on the scholarly side before we get back to the doctrine?
Yeah, sure. So you mentioned criminal law, and one of the groups that I want to be in conversation with are other criminal law scholars and people who are focusing on criminal law. So the criminal law is very concerned with the regulation of violence and also with the regulation of the instruments of violence. I think it's no coincidence that most of the regulations that I come across dealing with firearms and with other weapons are rooted in our penal codes. So to the extent that I can tease out an intersection between the criminal law and the Second Amendment, that's obviously interesting for me as somebody with both those interests, but I would love to lure in other criminal law scholars into the conversation. But beyond that, most obviously, I think I'm in conversation with those scholars who are focusing on how Second Amendment doctrine should look after Heller, and where we can look to for inspiration. And one of the reasons that I love Second Amendment doctrine, and you mentioned this before, is just we're getting in at the ground level here. So it's one of the things that drew me to this as an intellectual interest at the outset. One of the judges said that the Second Amendment is younger than the first iPhone, and it just sort of shows and demonstrates how new this whole thing is. I mean, Heller was decided in 2008, and yes, there were rights to keep and bear arms throughout the states. There had been a few scattered opinions that were addressing Second Amendment doctrine, but by and large were on the ground or near the ground with respect to how federal courts are interpreting this right. So trying to engage in that conversation, which has gotten more and more interesting, I think, over the years, is another focus of mine. And, I'd say beyond that, there is a conversation whenever you're engaging in Second Amendment doctrinal development with those scholars who are interested in implementing constitutional meaning more broadly. Mm-hmm. Mm-hmm. And in particular, with my piece, I drew a lot from scholars who had looked at the notion of constitutional borrowing, taking from one area of constitutional law or of law, in my case, and using it to inform and construct doctrine for a less developed area of law. And I think that, a move that my paper makes is to look to self-defense doctrine to implement a constitutional right. And I think that raises some interesting questions about whether and how you can look beyond the four corners of the Constitution to implement a constitutional right.
It's a really good point worth emphasizing that, people who are writing in the area, I feel like all of us who are here, get so struck by the fact that every question seems to be open, every methodology is on the table. There's interesting debates happening at so many levels here, which in other areas isn't always true. I mean, in criminal law, I don't know what the equivalence would be, but I'll say for me, working in constitutional rights law, it's radical, the difference between what's been resolved or what's been thoroughly debated in First Amendment law as opposed to Second Amendment law, where it really is first principles are still kind of up for grabs. Having said that, your piece, because it's just, as you said, at what the Second Amendment, what the Supreme Court says in Heller is the core of the Second Amendment, right? This right of self-defense. It's almost amazing to me that it took more than 10 years for somebody to write this article showing how the doctrine of self-defense might inform the doctrine of the Second Amendment. So I kind of have to ask the like $20 bill on the ground kind of a question, like, if it were there, somebody else would have seen it. How do you think nobody saw this before? Because every time I reread it, this may be a better question for myself. Like, how did those of us who didn't write the article not see it? Like, how do you think nobody came across this idea before?
Well, you know, I think that it is true that the intersection between self-defense and the Second Amendment it hasn't been a huge focus of the doctrine and the jurisprudence up until now. I can't say that I just developed this thing out of whole cloth. There were some people who were thinking a bit about the role that self-defense might play. And I mentioned before that Justice Breyer had said something in his Heller dissent that got me thinking. One of the things that Justice Breyer did in his dissent when he was characterizing the majority opinion, and this was in particular with respect to the safe storage law that was at issue in Heller, and that law, as you know, it prevented somebody who lawfully owned a firearm from accessing that firearm and loading it and having a loaded firearm ready to use for the law, for lawful self-defense. That's at least how that provision was interpreted by the majority. And what Justice Breyer says in his dissent is he characterizes the majority as requiring jurisdictions to permit somebody to access and load a firearm when necessary, shortly before common law self-defense rights might kick in. Mm-hmm. So he's making a point there about how the law of self-defense might provide some sort of a temporal limitation on when the right to access a loaded firearm kicks in. And there wasn't any pushback on that notion in the majority opinion. So what I'm doing is trying to build out that into more structure in terms of how Second Amendment doctrine should look. There are a couple others who have been influential for me, at least, in terms of thinking through the law of self-defense and the Second Amendment. One is your colleague and our friend Daryl Miller, who's also a mentor of mine, and he wrote a great article in the Journal of Law and Contemporary Problems, looking at self-defense and how that might inform Second Amendment doctrine. Paul Robinson at the University of Pennsylvania has considered some of these questions in the context of non-lethal weapons. And I'd say that another conversation that informed me in trying to build this out is that there are a group of scholars out there who are debating whether or not the Second Amendment in Heller had the effect of constitutionalizing self-defense. Now, it's a separate analysis, but people like Nicholas Johnson at Fordham have been engaging in that conversation. So I can't take all the credit for thinking about self-defense law here, but
yeah, I don't perceive you to be taking it. I'm just trying to give it to you. And I should say, for everybody listening who hasn't yet read the article, Eric is very clear in his footnotes to give credit to those who've come before, including people like Nick Johnson and also Dave Capel and Nelson Lund and others who've written about sort of the theoretical intersection between self-defense law or self-defense sort of as a right and the right to keep and bear arms as a right. But then there's that doctrinal payoff question. So I want to ask, I guess, maybe a follow-up to kind of situate your argument in how people might look at the doctrinal kind of payoffs, because it feels from the article like you're kind of in between the two extreme positions. So there's one extreme position, which, as you note, is actually pretty common in the court decisions, where courts will just ignore the law of self-defense, right? They recognize Heller and recognize the right to self-defense, the right to keep and bear arms with self-defense at its core, but not actually turn to the doctrine at all. And then there's this other set of cases, which I think is a smaller set, cases maybe like Wren in the DC Circuit or Young versus Hawaii in the Ninth Circuit, where courts reason a little bit like the following, which is the right to self-defense is a fundamental right, maybe the most fundamental right. The right to keep and bear arms exists to give people the ability to prepare themselves to exercise self-defense. The need for self-defense could arise anywhere, wherever you happen to be. It's not just in your home. Therefore, any restriction which limits your ability to have a gun on hand should you need to engage in armed self-defense is almost facially unconstitutional. it's almost the opposite of the ignoring self-defense. This really puts it kind of front and center. What's wrong with that second view? We've established that the first view isn't right. You should be paying attention to self-defense, but what's wrong with kind of making it like basically a bright line rule?
Right. So Wren and there have been a couple other cases like it, focus in on just one aspect of the law of self-defense, which is almost a truism. It's that that you have to engage in self-defense wherever you are, and kind of it takes that single focus and uses it to justify a very expansive right to keep and bear arms. You know, as I read Wren, you have a presumptive right to carry a handgun virtually anywhere. You can be perpetually armed with a handgun in case you need to exercise lethal self-defense. And one of the issues that I have with that focus is that it overlooks the more nuanced framework that the law has in place for actually implementing the right to self-defense, things like necessity and proportionality. So I think that if you actually look at necessity and proportionality, if that's part of the equation, you might come to different conclusions. I mean, one of the ironies here is that if self-defense and lawful self-defense is at the core of the right to keep and bear arms, necessity is central to self-defense. Self-defense law is all about necessity. And cases like Wren conclude that it's unconstitutional to even consider necessity when trying to determine when the right to keep and bear arms kicks in.
That's a really fascinating question, and I want to stay with it because a fascinating point, and I want to stay with it because we've been talking about the payoffs that this article has for sort of scholarly discussions, but it's also an article which has potential guidance for case outcomes. I mean, cases like Wren and Young versus Hawaii potentially look differently if a judge or a law clerk or a litigator reads this article and is sort of convinced by the thesis. So I wonder if you could just pick an area of law, of Second Amendment law, or firearms law, and say how it would look different if one of those people, a judge, let's say, picks up the article and reads it and is convinced. What changes in the world?
Well, so I don't think that I think that the fit works well in areas where firearms are regulated in the context of actually taking up loaded firearms for use in self-defense. So I'll stick with the public carry example. So the public carry Second Amendment challenges have largely been brought to these good cause laws. Most of the country, a lot more of the country had been within one of these jurisdictions, these regimes, but now I think about 25% of the country lives in a place where there's a good cause requirement in order to get a permit to carry a gun. And what this basically means is that you need, as you know, and you've written on this, that you need to show some articulable need for having a handgun for self-defense before you're eligible for a permit to carry one in public. So there's a circuit split on this. There are a couple cases that are pending before the Supreme Court right now, cert petitions pending, that deal with this issue. So the framework that I'm building out in this article would not take issue with these good cause laws to the extent that they already bake in necessity into the regime. You need to show some need for the handgun in order to be able to carry it. But I do think that a tight importation of self-defense law would require some sort of an exception in circumstances where you don't have enough time to get a permit, and you can show a need to have to carry a lethal weapon with you for self-defense purposes. And this could get implemented the same way that the right to self-defense gets implemented as an affirmative defense after violation of the restriction on public carry. Mm-hmm. So, I think that that's like roughly how this framework might work in that context. It's certainly it would be exposed to objections. But one thing that I think makes it not all that far-fetched is that there's some interesting historical precedent out there that looks like this. And I point to some of these old laws in my paper, but one that I'll reference right now that I like a lot, in part because it's from the Lone Star State where I am. And it's an 1871 law from Texas that banned, it went further than our current public carry regimes. It banned public carry altogether, but then set up an affirmative defense for people who could show a reasonable fear of harm to their body. I'm paraphrasing here. And so it basically did what the framework that I'm proposing would do. And this is an interesting example because it led to some litigation. It was enforced after it was passed in 1871. It led to some litigation, and it was challenged as violating the Texas right to keep and bear arms. And that case went all the way up to the Supreme Court of Texas, and the Supreme Court of Texas upheld it. And in upholding it, it relied expressly on this carve out, this affirmative defense that allowed somebody to carry a pistol when they needed to for self-defense. So it was state constitutional law. So it's not a Second Amendment case, but it is a law and some case law that shows potential interconnections between self-defense law and at least the right to carry weapons in public.
That's really fascinating. I want to, if I can sneak in one more like substantive question, or sort of like, it's a little bit zooming out kind of a question about how your paper kind of intersects with these constitutional interpretation debates about how do we think about how to implement constitutional rights. So your paper, as I read it, takes a position that's kind of what some people call purposivist, right? Like you look for what is the right meant to protect, and it could be for speech, democracy, or the marketplace of ideas or whatever, and you build doctrine in order to protect that purpose, right? And you start with the proposition of, well, the self-defense core of the Second Amendment is given to us by Heller. We know what it's for, and so we build doctrine to kind of further that purpose. I wonder if you could say a little more about that, because it may be of interest to sort of constitutional law scholars who are thinking about that relationship between meaning and doctrine, which some people will try to find just in history. We don't look to this purpose behind it. We just look at what did people do in the past. We follow it today. And your approach strikes me as a little bit different. Not asking for a full theory of constitutional interpretation here, but just kind of, to help maybe say a little bit about how to situate your piece for those who are steeped in the interpretive debates anyway.
Yeah, so I mean, a lot of, and this is something that you and Daryl have pointed out in some of your work as well, but a lot of the theory, the Second Amendment theory, is often running in parallel to, but not necessarily intersecting with, Second Amendment doctrine. And I do think it's important for the two to interconnect. The purpose and the theory behind the Second Amendment should inform the doctrine, in my view. And I think one of the risks of ignoring it is that the doctrine could run away from Second Amendment theory. So I do think that one of the things that I'm trying to do with this paper is to take Second Amendment theory as it's handed down to us in Heller and try to find a way for the doctrine to implement that theory, to find some interconnections between the theory and the doctrine.
That's fantastic. I like to end on a kind of a forward-looking note because it sort of like gives us a preview of what's to come. Thanks so much for being with us, Eric. This has been a lot of fun.
Thank you. It's been great to be here. Thanks for having me.
Awesome. And thanks to all of you who've been able to join us. You can, of course, reach out with any comments, questions, suggestions. You can reach us by email at firearms@law.duke.edu. Find our webpage at law.duke.edu/firearms. Find us on Twitter at Duke Firearms Law, or follow our blog, Second Thoughts, for more content like this. Until next time, I'm Joseph Blocher.